People of the State of Michigan versus Christopher Gordon. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under the penalty of perjury?
Yes, Your Honor. OB8, of course, is for victim exportation or captivity. A victim was exported to another place of greater danger. I don't think that that's our case. Or to a situation of greater danger. Again, I don't believe that that's our situation here. Or was held captive beyond the time necessary to commit the offense. Beyond the time necessary to commit the offense, not complete, but to commit. And so I just don't see it as being scorable at all. Thank you.
Response?
At the preliminary exam, she went further to state that she told him to stop. He said no, and she had to bite him in order to get away, forcing her to bite him, which means that she was held beyond the time necessary to commit the offense.
Anything further, counsel?
That reasoning suggests that 2 seconds would be a sufficient amount of time to complete the act.
I agree with that.
That would be a sufficient amount of time to complete the act. And it, as we are all instructed, the time necessary to commit the offense, I don't know that there is an exact time to commit that offense, even as described by the 9-year-old.
I think even the Supreme Court has ruled on this. I think it's in the jury instructions. It's no matter how long, it's the touching. So I agree with the people, adopt their argument, and totally disagree with you, but nice try, counsel. It is 15. On behalf of the people, do we have a victim or a representative of the victim here?
We do, Your Honor.
We live in a world where children are further desensitized by traumatic experiences due to no control of their own. Every day, we as adults have a choice in our behavior that impacts the trajectory of our children's lives, both directly and indirectly. I wish that someone loved and protected you when you were sexually abused. I wish that the healing that needs to be done in your family is underway. I wish that my daughter felt safe enough to be in this courtroom to hear you say you're sorry. I wish that your other children can experience real love from a father that cares, supports, motivates, and encourages them to be better for themselves and for their community. I wish that you find accountability within yourself to move forward in life differently. No more running from your problems because you're creating problems for those that are around you. Remember what it felt like to not have someone on your side fighting for you, believing in you. Hiding in your shadows of your truth, only for it to be revealed through your behaviors. I've watched you show up in this courtroom with all the sense I've known you to have, yet no audacity for the table I've extended to you in your times of need. Your slander, the grace, the position and sacrifices I've made for your behalf and your satisfaction. It's very disgusting to be on the opposite end of a lens and watch you in your presence and still hear your lack of remorse you have. I can accept the things that I cannot change. I want to thank you, Judge, for demonstrating patience and understanding in all of those before me as I've witnessed. It's because of your strength and tenacity that I can pull through rough days. As a behavior interventionist from school, I get days off and vacations and time to be away from all the duties of work. It's still a rough job in the schools, but I can't imagine hearing indescribable acts of adults and still having the grace to just be calm and cute. Women like you are inspiring to daughters like mine with the knowledge to lead and excel in all that you do. Showing up is the easy part. Having the tenacity is the admirable act of service. Thank you.
Man, I'm not the strong one here. You are. Stand here, loving your daughter and knowing what you did, and speak on her behalf. That's a true hero. And that's what you are. You're the strong one. And your daughter has just an amazing role model. And the reason she's going to get through this is because of you. Now, is the restitution that you're seeking, is she in therapy? Is there any money that you are spending because of what he did?
No.
Okay. I am going to order, if it's okay with you. I've done this many times. As far as I know, I'm the only judge that does it. At some point, maybe somebody will tell me I can't do it, but I really don't care. I'm gonna keep doing it. I'm gonna order a copy of this transcript. If you would like, you can also have a copy of the plea transcript. The reason I do that isn't to hurt you or your daughter, but as your daughter gets older, and she's certainly going to remember these events, she's going to need her own therapist, who I call a secret keeper. So she can have a conversation to know that her mother spoke on her behalf, that her mother stood up for her, that the court listened, the prosecutor listened, and that justice, as good as it can be, can't return things backwards, but it can change her life and the life of others because of you and your daughter speaking up. He cannot offend anyone else, at least while he's in lockup, and we're going to try to get him some treatment. So I want to know her to know that she was heard. And I believe that a therapist is only as good as the knowledge they have. So this would be given to you in a sealed envelope. If you want to read it, that's fine, but I would suggest that you only reveal it to her therapist and to her when she's of age, so that it can be used in her therapy to help her become whole and happy, know that she is clean and safe, and she did nothing wrong, that he did everything wrong, and that you also did everything right. So is that all right with you, ma'am?
Yeah, sure.
Okay, so the Crime Victims Unit will be giving that to you.
Yes.
I really, really appreciate your strong voice and you protecting all our kids, because when you report, when you stand up and say no, then you are the example for others who don't have that strength. So you and your daughter are both heroes. Thank you for being here.
The plea bargain was made in contemplation that dismissing one count of CSC 2 would drop the guidelines to 29 to 57. I did not realize there was a juvenile history in Florida that I had some of, not all of it, when we calculated the guidelines. So the probation department found a little bit more. That's what made the guidelines ultimately 36 to 71. I think there's a new case and a new court rule that indicates that although that might not be part of a plea agreement, which it was not, that if it's explicitly articulated that it is the motivation for the plea agreement, that that it might as well have been part of the plea agreement. So I'm going to ask the court to sentence the defendant within the range of 29 to 57 months. I'm actually going to ask the court to sentence him at the top of the guidelines to 57 months, because ultimately I think that's fair. That's what we thought the negotiated plea agreement was going to have the guidelines as. That's what I consulted with Mrs. Houston about. But I think the law actually requires that. So I'm going to ask the court to sentence him to a sentence in the Michigan Department of Corrections of 57 months to 15 years with credit that he's entitled to. That also will require lifetime electronic monitoring is already on there.
Being a parent myself, I absolutely can understand and appreciate Ms. Houston and her position. She's here acting as an advocate on behalf of her child. I agree with the comments and sentiments offered by the court. I say that to now say this. Based on my reading of the pre-sentence investigation report, particularly on page 5, the daughter was admitted to the hospital for UTI, urinary tract infection. I cannot imagine how that is associated with this case.
Because UTIs, every woman knows, I suppose men don't know this, but UTIs are, especially in children, are an indicator that there may be sex happening, and newlyweds get UTIs all the time. I mean, ask every hotel that has a newlywed suite, they have a doctor who's seeing the newlywed. That's why.
Yes, Your Honor. And this is a criminal sexual conduct in the second degree, where it's undisputed that the child was fully clothed.
I got that.
Okay.
But as a parent, and you just said you're a parent, I would have the same exact concern. Is there something else going on that I need to know about? And there's lots of medical reasons that happens, but there's also sexual reasons and concerns. So as a parent, I think it's right for her to go through that thought, to go through her mind and to go through those machinations of how did she get this? So I don't fault her. It's not something I'm considering. I'll just say that for the record. Thank you.
In the process of completing his general education degree, he has completed the PATS coping skills program. He showed the probation agent certificates of completion that was also included an anger management class, some mental health issues, and employment. So he has taken it upon himself to try to rehabilitate himself while he has been incarcerated, and I think that is something of significance for consideration. With respect to the actual sentence imposed, I know that my client is going to speak to the court in just a moment. Respectfully, 36 months to 180 months, if that would please the court.
Thank you. Sir, what would you like me to know?
Well, I do apologize for my negligence and not being able to make her feel comfortable to come to me and talk to me about that.
I didn't get that. And not being able to make what?
Not making her feel comfortable enough to come tell me what was going on.
You mean the little girl?
Yes.
Wait a minute.
And,
You're apologizing for negligence for her not telling you what was going on when you are trying to have sex with her, although fully clothed? Is that what you're telling me?
no, that's not what
Then explain what you mean, sir.
just me being a father, I haven't made her feel comfortable to tell me about what's going on because I didn't.
Why do you think a victim has to tell you what's going on?
Okay.
You're the adult, you know what's going on, and you knew it was wrong. No means no. She had to bite you to stop. She did tell you, and you didn't stop, and she bit you. I'm not understanding this at all. I don't think you learned anything from those classes.
I have learned from my classes, Your Honor.
Then speak in English or make up a different story, because I'm not believing a word coming out of your mouth.
I just really apologize for my negligence.
Sir, you are 33 years old.
Yes, Your Honor.
Sorry, I don't understand.
Sorry doesn't understand now. All right, look, you're 33 years old. You have a criminal history that I could wallpaper a room with. You have a juvenile history that's extensive. Granted, a lot of things were dismissed. I don't know what happened there. There's lots of reasons things get dismissed. But then you don't get so lucky. In 2011, you have resisting an officer. Again, you have dismissal of very serious charges. I don't know. So you're presumed innocent, but when I look at this pattern here, some more assault of crimes that are dismissed, and then you have drug possession.
That too was also dismissed.
You what?
That too was also dismissed.
I have 60 days jail, fines and costs, so it wasn't dismissed. Controlled substance possession.
They didn't charge me. That was thrown out.
Not what it says here. Do we need to amend this further? What was this counted?
Which count, I'm sorry.
7 of 12 in 2022. He had a possession of a controlled substance.
Well,
Looks like it was a plea. 60 days jail, fines and costs.
I can tell you that I verified it in the lien because that's how I knew to have you do the correction assigned counsel.
Yeah.
It shows as a plea in the lien.
Then we have a theft of a vehicle, which just was dismissed. And then in 2023, we have resisting arrest, fraud impersonation, fleeing, eluding, driving while license suspended. Not the worst crimes I've seen, but there is an escalation that I'm seeing. Because then we go to aggravated assault weapon. And then we have another thing that's dismissed. Now we have the biggest one. And what really, really concerns me, defendant denied that he is interested in any fetishes, voyeurism, attraction to pre-pubescent females, males, or anything else he felt worth noting. Well, we have a pre-pubescent female here. You admitted to it, but you deny it here. I don't think you are being truthful nor truly accountable. I appreciate that you've done some work while in jail. You have not been idle, but the work that you need to do is on the criminal sexual conduct. And sir, I don't like this deal. I don't like these guidelines. I do have the ability to sentence you 10 to 15. That would be 120 months to 180 months. And that's what I feel like doing. Because you weren't getting it. And because I believe that you need more time. However, because of this guideline debacle, and because I don't want this little girl to have to face a trial when the Court of Appeals tells me to resentence you, or you can withdraw your plea, all the other things, I think the family needs closure. I think mom's going to get the help her daughter and her family needs. So I'm going to sentence you to the Michigan Department of Corrections for 50 to 57 months, which is the high end of the guidelines of what was anticipated and contemplated and discussed. 57 months to 180 months. You have credit for 650 days. You have lifetime electronic monitoring. You comply with SORA. You'll have no contact. You communicate with them directly, indirectly, through third parties. You get creative and send a Christmas present, a Hallmark card, flowers, carrier pigeon, message, smoke signal. You communicate in any way, shape, or form. I will contact the warden, and they will not allow you to have any communication. All your friends and family, if there are any who want to see you, will have to come see you wherever you are so situated. So don't tempt your fate, sir. You are going to pay for the costs of the plea and sentencing transcript. That is for the rehabilitation, health, welfare, safety of the little victim whose life you altered forever. She is no longer that innocent 9-year-old. Not only does she know things a 9-year-old should not know, but she lives in fear. God granted her a strong mother. And I believe that she will be healed, because she will never forget. And that trauma will live inside her and will rear its ugly head at times when you least expect it. And you caused that. And you had no right to cause that. No right to affect another human being. Is there anything else I need to address?
No, Your Honor. Thank you.
Oh, there is. He has to pay $130 crime victims and $68 state cost.
For the record, I'm handing my client a notice of right to appellate review.
Sir, you have 42 days to appeal and to request appellate counsel.
You acknowledge that I gave you that form.
To appeal.
To appeal, if you would like to appeal this, that's how you do it. You only have 42 days to read it and consider it and fill it out. You understand?
Yes. Yes, Your Honor.
Any questions?
No, Your Honor.
Adrian Wilkerson stood before the court hoping for mercy, but the judge had none to give. The case stemmed from a fatal shooting that took place inside a Michigan nightclub. Adrian, a convicted felon, admitted to killing Christopher Bonia and pleaded guilty to manslaughter and felony firearm charges. However, throughout the sentencing hearing, he repeatedly portrayed himself as the victim, claiming he was attacked first and forced into an impossible situation. The victim's family painted a completely different picture. Christopher Bonia's wife, Magdalena Bonia, tearfully told the court that her husband was the heart of their family. He had raised her daughter as his own since she was 2 years old and spent decades building a loving home. She said life would never return to normal and that no sentence could bring him back, but she hoped the court's decision would speak for him one last time. Christopher's daughters echoed the same pain. One described her father as a kind and compassionate man who always treated people with respect. Another called him a gentle teddy bear who adored his grandchildren and would do anything for others. They said their family would carry the pain of his loss forever. The prosecutor then turned his attention to Adrian. He argued that Adrian wasn't a victim at all. He was a felon with a long and violent criminal history who made a series of reckless choices. On the night of the shooting, Adrian illegally carried a handgun, tucked it into his waistband, walked into a strip club, and drank heavily. When tensions rose and a fistfight broke out, Adrian didn't walk away. Instead, he pulled out his gun and shot Christopher Bonia in the stomach. And afterward? He didn't call 911. He didn't help the wounded man. He didn't wait for police. According to the prosecutor, Adrian calmly placed the gun back into his waistband, walked out of the club, got into a car, and vanished. The murder weapon was never recovered. The prosecutor slammed Adrian for trying to tarnish Christopher's reputation in his sentencing memo while refusing to take full responsibility for his own actions. He reminded the court that Adrian had already served prison time for witness intimidation in a murder case and still chose to carry an illegal firearm. The defense pushed back. Adrian's attorney argued that his client had turned his life around. He earned his GED, obtained a commercial driver's license, worked 2 jobs, and stayed away from trouble for years. The attorney insisted Adrian never expected violence that night and claimed he was sucker punched and attacked by multiple people. Adrian himself addressed the court. He apologized to the victim's family and said he regretted returning to court after promising his mother and himself he would never be in this position again. He told the judge, "I changed everything about who I was." He spoke about therapy, work, and how far removed he was from his old lifestyle. He claimed he never imagined he would be attacked and said he would one day answer to God for his role in Christopher's death. Then he asked for leniency. The judge wasn't convinced. She immediately shut him down. "I have no leniency and no mercy to give you," she said. The judge criticized Adrian for wanting credit for the good things he had done while ignoring the fact that he illegally carried a gun into a bar and used it to kill someone. She reminded him that he had choices. He could have stayed home. He could have left the gun behind. He could have avoided drinking. He could have fired into the ceiling if he felt threatened. But instead he chose to shoot a man. Taking a